Back, it is Eric Erickson here across the nation. I want to dive into a topic that might put me at odds with some of my friends. And it's a case before the Supreme Court. It's a sad case you need to know about. The case is called Gonzalez versus Google. I'm not a big fan of Google or Alphabet Incorporated. I don't think they are fair to conservatives. I think that the more we have learned about the progressive activists who work within Google, we should view Google with caution. But I hope they win this case in the United States Supreme Court. In this case, it's brought by the family of Nohemi Gonzalez. She was a college student. She was more than one of 100 people killed during a terrorist attack by ISIS. She, if I remember right, was in a nightclub that was bombed by ISIS in 2015. There were a series of terrorist attacks. The family is suing Google and Twitter in a separate case, different family related incident. But they're suing social media companies. Google in particular is on deck here because they argue that Google's algorithm led people down rabbit holes, particularly ISIS recruitment videos and other ISIS videos were on YouTube, and that the algorithm radicalized people. There is no evidence that the terrorists saw the videos. I'm flabbergasted the case got this far. There is no evidence the terrorists saw the videos on YouTube. But the family, and I will read from the Wall Street Journal here, the family or the plaintiffs allege that YouTube failed to take down some ISIS terrorist videos and even recommended them to users. They say that makes Google liable for damages under the Anti-Terrorism Act, although they haven't presented evidence that the terrorists involved saw those videos. In essence, the plaintiffs and their allies argue that Section 230 protection shouldn't apply to plaintiffs' algorithmic recommendations of harmful content. Now, we need to unpack that last bit here. Section 230 is what gave rise to the modern internet, and it is a source of contention for the left and the right these days. It is a statute, 47 U.S.C. Section 230. In particular, Clause C, Subclause 1. 47 U.S.C. Section 230 C1 says this, quote, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. That's one of the key points. No provider, under Section 2, subsection 2, no provider or user of an interactive computer service shall be held liable on account of any action voluntarily taken in good faith to restrict access to or availability of material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected, or any action taken to enable or make available to information content providers or others the technical means to restrict access to materials described. Now, this is the conundrum here. It says no provider or user of the interactive computer service shall be liable on account of any action voluntarily taken in good faith to restrict access, or any action taken to enable or make available the technical means to restrict access. It doesn't say They can avoid liability for any action voluntarily taken to enable access. Essentially, what the plaintiffs argue is that because Section 230 says that there will be no liability for prohibiting content, but doesn't say there shall be no liability for enabling content, that they should be sued for being able to enable content. However, the preceding subsection says no provider or user shall be treated as the publisher or speaker of any information provided. In other words, you can't claim that they are the publisher. You can't claim that they are the speaker for liability purposes. Now, this is somewhat complicated. I want to distill this down for you. What the plaintiffs and many on the outside are saying is that because Google's algorithm made ISIS content available for people, they should be held accountable for inspiring and emboldening and enabling terrorists, even though these particular terrorists may not have seen the information. I personally think that's a garbage argument. I personally think that there is no evidence, nor was any submitted by the plaintiffs, showing that these terrorists saw the videos. And you should not hold Google specifically liable for the actions of someone when there is no evidence that those people looked at the information presented through the Google search. That should be common sense. But people want Section 230 changed. And here is where I have got to part ways with some friends of mine on this. I do not believe conservatives should be arguing for the United States Supreme Court to change a law written by Congress. That is the height of progressivism. That's not conservative. Conservatism is saying, hey, this is a law drafted by Congress. Let's go to Congress with a plan to change it. You should not be using the Supreme Court to do what you can't get Congress to do. That's been one of the hallmark fights of the conservative movement for the last 50 years, since Roe v. Wade. You should not be going to court and telling the court, hey, we want you to reinterpret or add an interpretation to a law because we don't think the law is clear. Because it says actions to restrict, it doesn't say actions to enable, so therefore you should be able to do this. I don't think that's smart. I also think this opens a bag of worms for conservatives. See, one of the conservative arguments about Section 230 is Section 230 allows social media companies to police content without getting sued. They can moderate content. They can decide what gets seen, what doesn't get seen, who gets blocked, who doesn't get blocked. And a lot of them, Twitter in particular, but also Google, they have a bias against conservatives. I think it does everyone a fairness to admit there is a bias against conservatives. Progressives like to deny it. They shouldn't. It's true. Twitter itself, the Twitter files, as we've seen, as Elon Musk has opened the doors at Twitter, shows a relentless bias against conservatives by the former operator owners of Twitter. And what Twitter owners said is, well, this is Section 230. We get to moderate the content. And they used Section 230 to protect themselves from lawsuits for moderating conservatives. Some conservatives want to overplay their hand, though, and get rid of Section 230 altogether. Here's what happens if Section 230 goes away. The internet, as you know it, goes away. Joe Schmo goes on Twitter and says, Joe Schmo says of Joe Blow that Joe Blow is a drug-addicted pedophile who regularly abuses his wife and his dog, not to mention his children. Right now, under the law, Joe Blow cannot sue Twitter. He has to sue the person who said it, which is Joe Schmo. You get rid of Section 230, he can sue Twitter. And who do you think he's going to sue? His deadbeat neighbor who lives in the Double Wide, who wrote the nasty stuff about him on Twitter? Or is he going to sue Twitter, who hosted it? Right now with Section 230, Joe Schmo gets to say all the awful stuff up against Joe Blow and gets to slander him, and Joe Blow has to sue Joe Schmo for slandering him, not Twitter for providing the platform. Facebook goes away without Section 230. Comments go away on Instagram, and probably pictures too. Twitter gets shut down. YouTube has to go away. A lot of the modern internet goes away. Now, there is a portion of me that thinks this is a good thing for society if all this gets shut down by having Section 230 go away. Part of me, part of you got to acknowledge that there have been a lot of social ills that have come from the rise of social media. Suicide rates among teens has gone up, depression has gone up, despair has gone up, all sorts of other stressors in life have gone up thanks to social media. You get rid of Section 230, the house of cards falls down. Snapchat cannot stay in business. TikTok cannot stay in business. Twitter cannot stay in business. YouTube cannot stay in business. Facebook cannot stay in business. You get rid of Section 230, they suddenly become liable for everything every person says on their websites. They can't sustain it. There are not enough people available to read all of the content that gets posted and delete the stuff they think must be deleted. They rely on algorithms to do that. They rely on AI to do that. They would no longer be able to do that. Therefore, they would have to shut it all down. There are people who want to break the internet, and I am sympathetic to it, but it would be bad. We can't get rid of Section 230. There are ways to modify it. People way smarter than me have come up with ideas. But on the case at hand, this Google case before the Supreme Court, I hope you understand why it's really bad and why you should be on the side of Google. Sometimes you have to hope that the people you don't particularly care for win because there's a greater policy position at stake here. The idea that Google should be liable for terrorists who maybe did not even see the content and the people cannot even provide evidence to show they saw the content, that's really bad. That's making Google culpable for a terrorist. We don't even know the terrorist used Google. We don't know the terrorist saw the videos. We don't know the terrorist was persuaded to become a terrorist by the algorithm. This is trying to find someone to blame because your daughter died and you can't blame the terrorist who killed himself. So you're going to blame the company with the deep pockets so you can be consoled in wealth. That should be anathema to all of us. That should be bad form for all of us. I pity the parents who lost their child. But the idea that Google is responsible for the death of their child and they have no evidence whatsoever that Google caused the terrorists to become terrorists, that's bad. That's bad form. That's bad law. That's bad everything when it comes to setting precedent. And you should not support that no matter how much you don't like Google. You should not support suing Google because somebody somewhere in the world did something bad and they might have been able to Google how to do it, but you don't know whether they did or not. And that's what this case argues. There are ways to reform Section 230. To my conservative friends, do it through Congress. For 50 years, the conservative movement has argued that when the left can't get its way democratically, it goes to court. Do not become the left. Our ways cannot be their ways. Find a way to make a compromise, build a coalition, and get it done through Congress. Do not use the Supreme Court to do your legislative bidding because then you're no better than the left. Section 230 can be fixed. To fix it in this way, in this case, would be bad for all of us. I hope you understand why. To sue a third party because someone did something bad to you, and that person may or may not have used the third party, and you have no evidence they did use the third party, but because they might have used the third party, you should be able to sue them. No, that's a terrible, terrible precedent to take. And the Supreme Court and you and I and the conservative movement that has always opposed judicial rewriting of legislation should be on Google's side, even as we recognize there's room to fix Section 230.